SJC-11796, Commonwealth v. Eric A. Jewett.
Jewett.
Please proceed. Good morning, Mr. Chief Justice, Your Honors as well. May it please this honorable court. My name is Attorney Todd Pomelone, along with co-counsel Chase Marshall. We represent the defendant, Eric Jewett. This case presents a first impression issue of great public importance, dealing with two issues, one of which is the power of police to effectuate a warrantless arrest in the private dwelling of a citizen of the Commonwealth of Massachusetts for a jailable misdemeanor offense. This is the opposite of the so-called fleeing felon rule. Mr. Jewett's garage was entered into late morning, Saturday into a Sunday morning. Police officer sees him leaving a bar in Newburyport. Suspects that there may be something amiss because when he exits out into his truck, says he takes too wide of a turn. So the police officer then follows him, sees him swerve over a fog line. So at this point in time, you have a marked lanes violation, which is a civil traffic violation in the Commonwealth. Sees him swerve a few more times. So the police officer tries to effectuate a stop by turning on, activating his cruiser lights, eventually using his siren. Mr. Jewett doesn't pull over. He continues to drive, not at a high rate of speed, but at or below the speed limit. Eventually approaches his dwelling. The police officer tries to get him to exit his vehicle. He does not. He drives into his garage, which is attached to his home. As the garage door is coming down, the police officer uses an ice pick to stop the door from coming down, enters into the dwelling. There's a scuffle between himself and Mr. Jewett. Mr. Jewett eventually gets pepper sprayed, and at that point in time, there's a door that's closed. Mr. Jewett eventually is arrested, and based on this, the entry into his garage and his dwelling, the officer observes odor of alcohol, bloodshot eyes, the standard fare that you typically find in an OUI prosecution, and he goes to trial and he's convicted of an OUI third offense. At the point in time when Mr. Jewett was being followed by the police officers were not aware of any prior OUI convictions of Mr. Jewett. At most, the police officers trying to effectuate a stop for misdemeanor jailable offenses in the Commonwealth of Massachusetts. Now, the U.S. Supreme Court has never dealt with this issue specifically. There are two leading cases. One is the Welsh case, Welsh versus Wisconsin, in which the court held that the police could not enter into a private dwelling under the Fourth Amendment where at issue was non-jailable conduct. That was a civil violation of the law. And then you have the Santana case, another case in which police suspected felonious conduct and entered into a dwelling, and the U.S. Supreme Court said that that was justified. Now, courts throughout the United States are all over the map. There's a chart, actually, in my brother's brief, detailing the various approaches that courts have taken with this issue. This court and the appeals court have never held in a published decision that is permissible for police to enter into a private dwelling in the manner in which they did in this case.
Can I just ask you, how is it that you think that this would be a minor crime? I mean, this is a fairly serious driving danger to the public. I mean, this police officer was not unwarranted in following your client's car, who was swerving all over the place. Every reason to think that there was something wrong with the driver. And the driver, in a circumstance like that, represents a real danger to other people. How can this be considered minor? I don't understand that.
Well, the basis for why it would be considered minor, Your Honor, is that at that point in time when the officer decides to effectuate a stop, at most, Mr. Jewett, there's probable cause that he has committed either negligent operation of a motor vehicle or failure to stop. Failure to stop is punishable by no more than a $100 fine.
How about reckless or dangerous operation? Wasn't he charged with reckless or dangerous operation?
It was a negligent operation of a motor vehicle.
That's what he was charged
with?
And
OUI.
An OUI third offense.
But isn't it an arrestable offense without a warrant? Negligent operation?
It's not listed in the statute. There's a citation in my brother's brief about arrestable misdemeanor offenses, and negligent operation is not actually listed. But I think.
But does it amount to a breach of the peace in the presence of the officer?
I think it could in this circumstance, but at most it would be a misdemeanor breach of the peace.
Okay, but it arguably it's at least an arrestable offense.
Arguably, yes, it is, Your Honor. And
so the police officer has a right to pursue him.
That's correct. The police officer was attempting to stop Mr. Jewett, and Mr. Jewett failed to stop, went into his home, and that's the issue. Is
so if he has a right to follow him, and it is. He just basically has to say, oh, okay, you've gone into your home, that's the end of it? He can't do anything else? That's what
the issue, frankly, Your Honor, in the common law, you have the so-called fleeing felon rule, where the police officer has reason to believe or even probable cause that a felony has been committed in his or her presence. The police officer can effectuate a warrantless arrest and even enter into a private dwelling that's normally curtailed by Fourth Amendment protections. And what we have here is a misdemeanor offense. And the Commonwealth's approach in its brief would transmogrify every Chapter 90 driving offense into none of them would become minor offenses if anyone failed to stop. You can't surmise, we don't concede that there was probable cause in this case.
So the rule is, if you commit a misdemeanor, run fast, get to the house. That's the rule? Therefore, you can avoid arrest if you can just get in the door?
That's not the rule, Your Honor, but...
that's the rule you propose?
That's the Commonwealth proposes the opposite rule, Your Honor. The Commonwealth rule is that if you fail to stop for the police, regardless of the type of criminal conduct at issue, that you can always enter into a private dwelling.
Is that really what they're saying, regardless of the... I mean, first of all, I think they would... Well, I don't know. We can hear from them. But the negligent operation is something different than having a light, failing to signal or a variety of other things. I don't even know. Those are probably civil
Well, that's correct. But I think at issue really are you're going to have fact-specific inquiries on a case-by-case basis, and I believe what the Commonwealth's calling for is more of a bright-line rule. Now, I'm not going to speak for the Commonwealth, but on these facts, the Commonwealth claims, and the judge below found that there was probable cause to arrest for an OUI, primarily due to the driving erratically, driving over fog lines, and the fact that Mr. Jewett was seen leaving a bar. But, for example, if he left a CVS, would there be probable cause that this was an OUI drugs?
Didn't the officer know that before he got to the house that it was Mr. Jewett, and didn't he know something about his prior history?
He knew something about his prior history, but it wasn't clear from the record below that he knew that he had prior offenses involving OUI. The judge did issue revised findings of fact after Mr. Jewett filed a motion to reconsider, saying that the basis of the officer's knowledge, it wasn't that clear. At first, they thought it might have been a domestic disturbance. But after arrest, after being on scene and entering Mr. Jewett's dwelling, the officer did determine that he did have 2 prior convictions for OUI.
So you would draw the line at the difference between a felony and a misdemeanor, and that's it?
Not necessarily, Your Honor, but on these facts, I would
So what's the rule
contention
then?
that this would be a minor offense. Failure to stop is punishable by $100. The legislature has spoken as far as that's concerned. This only becomes a felony once the officers determine that there were 2 prior offenses. That doesn't happen until after the
So it is
warrantless
what Justice Link is saying. It's the difference between a misdemeanor and a felony. That's the line you want. Is that right?
I believe it's a close call. Not all. I would surmise that not all misdemeanors should take this approach, but on these facts, yes, the police were not justified in entering into his home. They had ample time to get a warrant.
How could they get a warrant? I mean, as it turned out, he went right out the back. I mean, how are they going to get a warrant?
Well, the evidence was that he went out the back after he had been pepper sprayed, and he was outside, and he was coughing.
But the point is, he could.
The point is he could have, but there were also other officers on scene, and the argument essentially is that he was attempting to escape by going to his home. The police officers, when he was being followed, the police officer was able to surmise that Mr. Jewett was probably driving to his home. He had his address. He was driving that way. Lo and behold, he pulls into the driveway for that address. This is where he lives. And then the police officer knocks on his car window, tries to get him to exit his vehicle. He does not. The garage door is open. He drives his car into the garage, and then the police officer jams it with an ice pick to stop the door from closing.
Here you have a combination of things. You have a fleeing misdemeanor, misdemeanant, rather than a fleeing felon.
Correct.
And you also have dissipating evidence. I mean, I'm not sure dissipating evidence alone would be enough, but you have hot pursuit and dissipating evidence. That combination seems pretty understandable as to why a warrant wouldn't be adequate.
Well, the issue of dissipation of evidence, Commonwealth conceded that issue below and didn't pursue it on appeal. So that factual scenario is different than the case at bar. But moreover, in the Commonwealth, for example, nobody has to submit to sobriety tests, nobody has to submit to a blood alcohol test, and the U.S. Supreme Court recently spoke that you can't force extrapolation of blood from a person without a warrant unless there are exigent circumstances that would justify doing so.
No, but you can smell, you can smell the liquor on somebody's breath.
Observe their instability, glassy eyes, I mean, all of those things which are evidence that certainly if he's able to escape and there's several hours before a warrant could be obtained, assuming he's still home, that would be gone.
I think on those facts, Your Honor, it would be the burden of the Commonwealth to justify not being able to obtain a warrant. Each case could be different, but I don't think you can do a carte blanche approach that every case that may or may not involve an OUI would necessarily cause a long time before the Commonwealth, the police officer could obtain a warrant. Maybe the police officer could have I had a case recently where the police got a warrant in less than 10 minutes.
Wouldn't it be a destruction of evidence claim also? I think the Commonwealth raised this. If he went into the house and said he just drank, he was nervous by the event and just drank a big shot of whiskey, and that would then make it very hard to ascertain through, even if you could get a warrant about alcohol level, whether it was the result of a claimed dilution or destruction of original evidence.
That could be possible, Your Honor, but I don't believe that claim was pressed below at the motion hearing by the Commonwealth.
It was.
That claim was not pressed below by the Commonwealth at the motion hearing.
How does a police officer tell when somebody's fleeing, when they can pursue them and when they can't? When is it reasonable?
Well, here you have the police officers follow. Officer Holcroft is following Mr. Jewett. He eventually activates his siren and his cruiser lights. Mr. Jewett doesn't pull over.
So what should happen?
What should happen is he should make an attempt to effectuate the stop. But once Mr. Jewett entered into his dwelling home, it's our contention that a warrant was required to enter into the home.
But does it, let's speak only of driving offenses which go to matters of safety. So negligent operation, reckless operation, OUI. If you're right, as you noted in answer to Justice Cordy's question, this is a little bit like the kids' game where if you reach home base, you're safe. Are we going to have a problem with people who are already maybe inebriated driving dangerously in order to get to home base, in order to arguably be protected from the kind of observations or to preserve what Justice Duffley mentioned as a defense? I mean, don't we have to worry about aggravating the risk that occurs on the road if you're right?
Well, that is a concern, Your Honor, but there's also the concern of every time a person doesn't pull over the police, that the police can just enter into dwellings, kick down doors, jam open garage doors from closing. There needs to be a fine line drawn to protect the citizens of the Commonwealth.
Well, in fairness, the garage door was being closed on the officer. It wasn't, I mean, you have to look at the circumstances here.
Well, the circumstances here is the officer tried to enter as the door was closing. That's correct, but he also tried to enter without a warrant as the door was closed. He could have, if the door was closed, he could have banged on the door, asked Mr. Jewett to come out. There was another officer that showed up less than 30 seconds later. Both officers were armed. They had cruisers. The fact that a second officer showed up within 30 seconds, I think it's fair that other officers could have been there or were within close proximity to the scene.
Counselor,
what really happened here is by entering the home, I think an exacerbation was created and it turned to a volatile situation that was avoidable if the police officers didn't try to enter the home and got a warrant.
Well, what if instead of a home, the defendant kept on driving and crossed into the territory of a different town? The police officer could have pursued him into the other town and made an arrest there for negligent operation, couldn't he?
I believe he could on those facts.
Yeah, and so here the defendant, instead of driving into another town, chose to drive into his garage and enter his house. And the mere fact that he enters a house deprives the officer of trying to protect the public and avoid an arrest.
It doesn't deprive the officer of trying to protect the public or avoid an arrest. An arrest warrant or a search warrant could have effectuated those same policy concerns. And Justice Hines?
Yes, I wanted to know if you agree with the Commonwealth's assertion in the brief that this arrest began on the street. Is that what happened? In other words,
Yes.
they have the
I believe
right
that's
to
accurate.
pursue him if he was intending to arrest him on the street. That would kind of strengthen the argument for going inside the house. And I wasn't clear that that was actually what was going on here. Do you agree with that?
Well, I believe the issue is a bit convoluted. I think at first the officer is following Mr. Jewett because he's of the wide turn that's made, and then follows him briefly, then wants to do a traffic stop. He's seen a few traffic violations. When Mr. Jewett fails to stop, that becomes a separate crime. But as far as operating under the influence, we do not concede that there was anything more than reasonable suspicion to investigate for that purpose. There was not probable cause on these facts. Only the evidence that's derived after entering into his garage would rise to the level of probable cause for an OUI. But I do believe you have probable cause for failure to stop, and also the observations attendant thereafter would be
and
negligent
then
operation.
if it's that, they wouldn't have a right to go into the house without a warrant if that was the basis of the arrest that began on the street. Is that your argument?
That is essentially our argument, Your Honor. And
Okay.
for example, if the legislature wants to make a felony to fail to stop for a police officer, they could do so, but they have made it no more than a $100 punishable offense. And for the reasons stated in our brief, we have a few remaining arguments. I would rest on the brief. And I would just respectfully ask this honorable court to overturn the suppression order to suppress all evidence in this case because the warrantless search and seizure of Mr. Jewett was unconstitutional under Article 14 and the Fourth Amendment.
All right, thank you.
Thank you.
Good morning, Your Honors. My name is ADA Phil Mallard. I'm here on behalf of the Commonwealth today. May it please the court. I'd like to just start off with the first point I'd like to make is that the privacy intrusion in this case into the defendant's home was a product, a consequence, the result of the defendant's flight. It wasn't a moment in time where I think the officer even had a chance to think about what was happening. It was a situation where, at the time in which he's in front of the garage, banging on the window with his flashlight, saying, stop the car, and the defendant drove in and closed the door on him. I think at that point, this scene and what resulted from the defendant's flight was a continuous, chaotic scenario that really left the officer no time to make the sort of leisured, scholarly analysis that obviously kind of guides every case that this court and other courts and prosecutors sort of present.
You hope.
Let's assume it wasn't quite so chaotic, but the officer had his light on and the defendant pulled into his driveway in the garage and closed the door. The officer got out of the car. So we don't have this chaos, the officer literally, physically trying to stop him. Any difference?
So I guess in your scenario, the defendant's...
Same scenario, except the defendant is a little further ahead and pulls into his driveway in the garage, closes the door. Officer pulls up, the light's on. He has, he put the light on a couple of blocks ago, and there was no stopping.
Well, I think the arrest for it to be... It's a little different than in the situation of whether the arrest had been communicated to the defendant or not. I think the critical question, the objective determination of probable cause, and the officer's subjective intent to arrest are critical. And the flight into the home, in this case, was certainly the intentional act of the defendant. But I can certainly understand that there would be circumstances where defendants may not know that they were fleeing from an arrest.
Could I go back to the warrant issue?
Certainly.
You've got your brother had a lot of questions about the warrant, but I'm not that convinced that they couldn't get a warrant. They know who it is. They know where he lives. Why couldn't they get a warrant for the arrest?
Well, I can tell the court a couple things about that. I think DiGeronimo makes a pretty strong argument about what could happen in the interim between the warrant and, the entry and then the time it would take to get a warrant. And just from clear geography of where that officer was in the nearest courthouse or the ability for him to get back to...
He needs a phone at that hour.
Correct, but then Chapter 276, Section 2B requires him to appear personally and deliver it, and if he's going to have the Nelson exception, where he can essentially present the warrant telephonically, he has to exhaust all other options and come to the conclusion that there is no means by which he could attempt to present a written warrant to a magistrate or neutral arbiter of that warrant. I only mention that because in other states that I don't cite, because there are circumstances and nuances of each and other jurisdictions, but where states have required officers to get warrants, not necessarily in hot pursuit scenarios, but in other scenarios, they have statutory options for the officers to get telephonic warrants, and they can simply call the duty line. A recording
So he's
starts.
not there alone. You know, when officers attempt to make arrests or searches in other situations, they freeze the area. I mean, if he comes out of the house, obviously he could be arrested, and you don't need a warrant in that situation. But the officer is not there alone, and as long as the defendant is in the house, why can't they get a warrant?
Well, I think the issue is, it has to step, there's the issue regarding the entry into the residence, the residential area, after the battle at the door, and the entry into the garage, I think, predates, it is antecedent to that, and that's the real issue, is when he crosses the threshold into the garage and the door is about to be closed and he takes the measures to stop the closing door. At that point, he's entirely alone in an extremely remote area, and my first exhibit, Supplemental 1, really kind of presents how rural and opportunistic it would be to an individual who wanted to flee out the back. As this officer was walking into this and banging on the window, he could see the three exits in front of him. There was the garage exit, there was the front door off to the right with the little path, and then there was at least the deck that he could see, which sort of went to the left of the garage and was up with stairs leading down, which is ultimately where the defendant fled. So at the time of the initial entry in that hot pursuit determination, the hot pursuit entry that was made, there were three exits that the defendant could make use of. He knew the layout of the house, obviously more familiar with it than the officer was, and it certainly would have been impractical, if not impossible, to secure it on his own and keep him in a place in which a warrant could be obtained for however 40 minutes, and then he have to wait for backup. I think it's safe to assume it would take half an hour, if not an hour, to obtain the warrant, and in that circumstance, the options described in DiGeronimo could have occurred. He could have intoxicated himself more and blown a 3-0 or something to that effect and blamed it on the whiskey he consumed post arriving at the home. But I did want to make clear that this dissipation of evidence and the exigency, the traditional exigency factors, are not something that I'm raising on appeal, because I don't think the factual record supports that. I think the statutes and the law concerning OUI has changed since DiGeronimo, that I think it would be ripe at this point to challenge it and to sort of bring the jurisprudence of this state in line with how serious of a crime OUI is, and even refusals of the breathalyzers have serious significance in terms of the administrative.
So are we just talking about, as Justice Gantz was mentioning, traffic misdemeanors which raise a public safety concern?
I think this case, Judge, will present obligations and will describe the obligations and permissiveness for essentially any misdemeanor. But there are some that come to...
So we're talking hot pursuit, number one,
Hot pursuit.
a fleeing suspect, number two. So
Correct.
that would eliminate the person who pulls into their driveway unaware that the police officer has just put on his light. So here there's evidence of flight, but there might not always be. So hot pursuit, fleeing subject, probable cause to believe that they have committed a misdemeanor for which jail is a possible sentence.
Correct,
That would be
Judge.
your line.
And I think that's critical. I think the rule that the Commonwealth proposed in this case is critical because it would incorporate the circumstances where there's a publicly situated assault and battery, a domestic violence situation at a barbecue perhaps, or something like that. The police arrive and receive information concerning the suspect who had fled into a home. And the hot pursuit exception, if he sees the individual and is prepared to make the arrest, and upon the initiation of that arrest, the defendant flees for an assault and battery, domestic violence scenario, I think it would.
So I'm sorry, so let's go back. You say the police officer arrives, let's say, at an accident and receives information that the driver of the automobile has left the scene and gone to his home. Is that a fleeing suspect? Is that hot pursuit? What's that?
Well, at that point, the officer would have had to intend to make the arrest. If the defendant was already at his home, as was the case
So
in
the officer
DiGeronimo.
doesn't have to see the individual fleeing.
Well, he certainly has to attempt to make the arrest, and the defendant must be, in some respect, within his presence to affect the arrest.
So it has to be an arrestable offense.
Yes. Probable cause.
Not just any misdemeanor for which there's jail.
Well, I think there's a requirement that the arrest must be effected in public, and negligent operation in circumstances without a breach of peace is not arrestable. There must be a summons mailed.
So the officer has to initiate the arrest while the individual is outside of the home and before, essentially, as he is trying to get into the home or outside the home?
There must be flight from a public place into...
From the officer?
From the officer, correct.
Okay.
And it need not be a hue and cry through the streets, but there must be some sort of continuous chase. That's the language of, I believe, a D.C. Circuit case interpreting Santana. It doesn't have to be the law and order scenario where the suspect flees at the moment.
In an attempt to effect an arrest.
From the arrest, correct.
When did the arrest begin here?
I would say the arrest commenced probably on the third turn where the defendant nearly struck the car as he turned on the Thorndike. I think at that point, there's clearly negligent operation. And
Is that when the officer turned on the sirens?
well, he's going down, he leaves the bar and they're going down the main road, sort of the highway type of road. And this lights and siren goes on after the weaving within the lanes and marked lanes violations. First left turn is, the lights go on and then the defendant makes the first left turn onto Attitash Road. And then from there, there's a right turn, so 3 total turns, and then ultimately the Mountain View Road becomes essentially his driveway. I'd say the third turn, there's certainly negligent operation. Coupled with the extended flight in this case, it's slow. It's probably less than 2 minutes that they're driving. But at some point over the course of that 2 minutes, the reasonable suspicion for this negligent operation matured into probable cause to arrest him for the breach of peace that was then observed at that point.
So is this limited to crimes that the police officer has observed?
Well, I think that is not the case in other jurisdictions, and I don't think, well, I was actually contemplating these scenarios in preparation for this argument, Judge. If there was an arrest warrant for an assault and battery on a domestic, I think that he could pursue the...
If there's an arrest warrant, of course he can enter to make...
Well, if it's not his house, then he'd have to go get a search warrant to proceed after him. But I think if he's in public and he commences the arrest and it's the individual named in the warrant, he could certainly follow him no matter what felony or misdemeanor.
So you would not require it to be perceived by the officer. So if somebody said he hit me and he's running into the house, you would permit him to follow, even though the officer did not see it.
I think that should be the rule, and I think that rule would encapsulate and permit the warrantless arrest of domestic violence offenders.
So the officer hasn't seen the conduct in that case?
Well,
And has no arrest warrant?
if he arrives at a barbecue or something or receives information of a domestic violence assault and battery, and then he observes the individual, and upon the individual understanding he's going to be arrested, takes off, I think the rule in this state and what Article 14 would permit would be for him to follow that individual into the home.
But if it were not a domestic violence assault and battery, and it did not occur in the presence of the police officer, and there's no warrant, what's the authority to arrest?
Well, it would have to be a warrant and a warrantlessly arrestable offense. That is a necessary requirement. There are not many, but there are a few offenses.
I should know this, but warrantly arrestable even when the offense occurs outside of the observation of the officer?
Well, in that circumstance, that it's very difficult because you cannot simply go into a home when you have an arrest warrant for anybody. You have to have a search warrant to proceed into a home. So
Not the person's home.
Right. So there's a lot of nuances to this, but what I would say is that warrantless arrest is permissible for a number of offenses, even when they don't occur within the percipience of the officer.
Like what, besides?
Identity theft, 266, Chapter 37E, and there's
These are the ones that are listed in the statute.
Right, where the warrantless power is enumerated.
But none of the ones that are at issue in this case are listed in that statute, correct?
Correct, Judge. One other thing I did...
Do you have to go there to decide this case?
No, you don't have to go to the full extent of the rule I proposed, Your Honor, but I do think that this case is an opportunity for this court to set a bright line rule, which I think would favor, which I'm certain the police would want, the courts below would want, and would prevent sort of officers second-guessing themselves when a bright line rule could be set. It would permit the prompt arrest, which is what the entirety of the warrantless arrest exception was premised on, was that the public safety would be improved by such arrests. And certainly, Chapter 90 offenses present public safety issues and also risk of escape as the mechanism by which the escape would be
Well, how about speeding? That's a Chapter 90 offense.
non-arrestable. If that speeding were to develop into a breach of the peace negligent operation, then I think that that would be sufficient. But without an arrestable probable cause offense, and setting the rule there, I think this court could establish a framework, a regime that would be sensible, reasonable, bright line, and give clear guidance to the police as they deal with these dangerous situations on essentially a daily basis.
Are you agreeing with Mr. Parlow that there was not probable cause before the officer was in the garage for an arrest for OUI?
No. I think that there was probable cause to arrest for an OUI.
As you said on the third, or no, that was something different. Yeah.
No,
Well, certainly before he entered the garage.
certainly before he entered the garage. And I do want to just comment upon the fact that had he stopped, had the defendant not taken this arrest into his home, he would have been determined to be a felon. He was a fleeing felon, and that's a fact that shouldn't escape this court. It was his flight that prevented this officer from developing the information that he was in fact a felon.
You mean felon because it was a third offense? Is that what you mean?
Correct. And just, there are scenarios like this in crafting the rule. I think this court should be cognizant of the fact that the defendants would be profiting if there were to be a sanctuary erected at their door, not even their door. It could be anybody's door. This was a case where he went to his house, but that might not always be the scenario. He may find the nearest door, the nearest open garage, duck in there, shut the door, and be essentially invading the property of another. And I just want to end on the request that this court set a bright line rule in accordance with the Commonwealth, but certainly one that will incorporate the ability for police to pursue fleeing Chapter 90 offenders for which they have arrestable offenses and probable cause to arrest, and also a rule that would incorporate the ability to arrest for domestic violence scenarios as well. If there are no further questions, I'd be happy to rest on my brief.
Thank you.
Thank you.